With the consent of the petition, I beg to mention item number 29, my lord. It will be taken after vacation. In the meantime, I will file my affidavit, my lord.
The contempt case.
Lordship, I have to file my affidavit, my lord. The full instruction has not come, my lord.
Mr. S. Boral and counsel for the respondent submits that complete instructions for filing affidavit is still awaited, and therefore this matter be posted immediately on reopening of the winter vacation so as to enable him to file affidavit. Since the prayer is made with the consent of the petitioner's counsel, same stands allowed, let the matter be listed accordingly. Yes.
Okay, lord.
May I please, your lordship, with the consent of other side, lordship, I beg to mention item number 11, your lordship.
Item
11. Lordship, in that the petition, I have to file affidavit reply also. My lord, matter may be taken up after vacation.
Mr. D. Boral and counsel for the petitioner prays for and is granted 3 weeks' time to file rejoinder affidavit responding to the counter affidavit filed by the respondents. Let the matter be listed accordingly.
Much.
May it please, your lordship. Lordship, I beg to mention item number 19, lordship. There's some little accommodation, lordship. I have consent from other side also, lordship, taken consent.
What do you want?
For adjournment for today, lordship.
On the prayer of Mr.
Lordship,
K.
may please,
Gogoi,
sorry.
managed CGC made with the consent of the other side, this matter stands passed over for the day. Yes.
May I pray for the listing of Sue IAS for vacation of an interim order, your lord.
Vacation, but after vacation or before vacation?
Preferably before vacation, your lordship.
You have come in the last moment. When do you want it?
Any date for the vacation, your lordship.
You fix the date. Put it.
Friday.
May I please, lordship. I beg to mention item number 8. I am praying adjournment today, my lord.
Item number?
8.
It is
After.
connected with 7. Item 8 is connected with 7. You are not aware.
I am not aware.
So there is a connect. You
Yes,
you
sir.
mentioned when the matter is
Yes,
called
yes, offline.
May I please, your lordship.
up. Yes.
My lord, I beg to mention item number 33, my lord, contempt matters, my lord. My lord, in this matter, my lord,
Yes.
in this matter, my lord, the order has been passed pursuant to the, my lord, judgment.
Mr. M. Islam Lanik Council.
My lord,
Huh?
and this matter, my lord, take with the, my lord, Ferris writ petition, which is fixed on 5, my lord, 5-1, my lord.
No, if the order has been complied with, then what?
No, my lord, it is not compliant,
Then
contrary.
you wait. When the matter is called up, we'll see.
May I please, your lordship? Lordship, I beg to mention for listing of a matter.
Hmm.
Lordship, the matter is pending since 2016.
When do you want it? Tomorrow?
Any
Huh?
day.
People are being very unreasonable. Just 2 days before the vacation, you want matters to be listed because they have been pending since 2 years.
Lordship, after vacation first.
After Bihu. After Bihu.
May I please, your lordship? I beg to mention item number 27, my lord.
Yes.
My lord, due to some personal difficulty, Miss B. Sodu is unable to present in the court, my lord. My lord, kindly adjourn this matter only for today, my lord.
This is a serious matter.
Yes, my lord.
You have informed the other side.
No, my lord.
You wait when the matter is called up. Inform the other side. Inform the other side. These are 4 or 5 cases together. Yes.
Lordship, I pay for listing of an IA, Lordship, if possible tomorrow, Lordship,
What
because
is the idea about?
Lordship, the petitioner is seeking promotion from the post of civil engineer, junior engineer, civil, Lordship, to the post of assistant engineer. And there is a communication from the secretary to all departments, Lordship, to convene a DPC before 20th, Lordship.
Right.
If his case is not considered, Lordship,
Why his case will not be considered?
Lordship, because it is being pending since 2009, Lordship, and he was not considered on the basis of merit, Lordship. They are promoting on the basis of seniority, and the rule says, Lordship, that he is to be considered in, if he acquires the qualification, he is to be considered on merit.
We'll see reopening, on reopening. These are not very urgent matters.
Because the DPC will be.
On reopening 3rd January. 3rd January. Yes, next matter.
Lordship, I beg to mention one listing of a fresh matter, Lordship, on Thursday, Lordship.
What is the matter about?
Lordship, this matter regarding Lordship appointment staff selection commission, Lordship. Lordship has already passed similar orders citing.
All right.
Lordship, I beg to mention item number 20. Lordship, we will file our affidavit in opposition in this matter.
Item number?
20. Lordship may grant us 3 weeks time, Lordship.
You are appearing for whom?
Respondent number 4, APTDCL.
Your name, please?
Wali Rahman, W Rahman.
You have informed the other side.
Yes, Lord.
Huh?
Yes, Lord.
But if they come and then I'll take up the matter.
Lordship, I beg to mention other two matters.
Wait,
that
wait,
will-
wait. Mr. W. Rahman, Learned Counsel appearing for the respond number respond number 6, prays for adjournment in this case with a request to look at the matter again after the winter vacation. The prayer is made with the consent of the other side, same stanza. Let the matter be listed accordingly. Which is the other matter?
12 and 13, Lordship. In this matter, my senior has some personal difficulty. He could not come.
Who is your senior?
Mr. A. Sharma.
The prayer of learned counsel for the writ petitioner. These matters stand adjourned for 3 weeks. List accordingly, 12 and 13. Yes.
Hello.
May I please, your lordship? I'd like to withdraw lordship tomorrow, lordship.
May please, your lordship. Lordship, I beg to mention for listing of a writ petition, lordship, matter pertains to lordship, the petitioner was not allowed to join in service, lordship, because one FIR was lodged against him. He, after getting the bail, lordship, he was not allowed to join in service, and neither, lordship, suspension order was issued to him, lordship. And last,
Motion matter.
no, for admission on last occasion, lordship, government took time on last 2 occasions, lordship. So day after tomorrow, if
No,
possible.
after vacation. You are too late. After
Immediately after vacation.
put a
Okay,
date.
lordship.
May I please, your lordship? Lordship, I am praying for listing of writ petition. The similar matter is fixed on 21, my lord. That matter,
What is the similar matter?
matter relates to one termination of Panchayat employee, my lord.
May I please, lordship, I beg to mention, matter for the listing.
Hmm.
My lordship, the step was taken on 27/9/2023.
Yes. 19 January. Put the date, 19 January.
May I please, your lordship?
Yes.
Non-compliance of the order passed by this honorable court, lordship.
Which is the order?
Order starts from page 13, relevant portion at page 30, lordship. Last paragraph,
Mhm.
page 30 and 31, lordship.
Yes.
Twenty-five E and 25F.
So, more than 1 year has gone already.
1 year, 3 months have gone.
The contempt case is not maintainable. You have to file within 1 year. That's the law.
Lordship, they have communicated, lordship, communication is at,
Communication is there.
lordship may kindly come to page 43. With reference to the letters, I am directed to request you kindly inform whether the amount of such and such in respect of such and such has been deducted by from his DCRG and pension benefits or not. Moreover, you are requested to furnish a certificate from DDO stating that the DDO will be personally responsible for any excess, overdraw, underdraw of arrear amount, and any irregularities in this regard shall attract relevant provisions of the AFR.
That's right. So for filing a contempt, is there any time period fixed or one can come anytime?
Lordship, they are communicating, they are asking for,
I am asking you something else. Is there a time limit fixed?
they were to comply within 1 month, lordship. They have not. They are asking for one
On the
certificate.
prayer of Mr. S. Chauhan, Learned Counsel for the petitioner, this matter stands passed over, is taken up. Come prepared on the law. This contempt case will close it. This is not maintainable.
Acknowledge, lordship.
May I please, your lordship? Could you withdraw the petition, lordship? To withdraw, lordship.
Withdraw. Why?
But actually, what happened, I applied for compensation appointment. Then department, then I filed an RTI. After receiving the RTI, they said we'll try to consider a case. So we'll forward
Without liberty.
with liberty, lordship.
No, with liberty, then you have to argue. Huh?
No, they are, as well as that I will forward my name, lordship. So,
But what do you say, Ms. Bhattacharya?
Lordship, actually, here in this case, the petitioner applied for compassionate appointment, but the father of the petitioner, he was actually removed to a disciplinary proceeding from service. But after his death, he died in 2015. After his death, the wife of the deceased, she filed an appeal. When the appellate authority considered everything, Lordship, and the removal order was This was taken away, Lordship. And thereafter, he has been given all the consequential benefit, Lordship. And that's why, as the person died in harness, Lordship, so he applied for the compassionate.
Now he wants to withdraw.
Lordship, it's
Mr.
up to
KD
him,
Sharma,
Lordship.
counsel for the petitioner, submits that he has instructions from his client to withdraw this writ petition with liberty to file afresh. The prayer is not opposed by Ms. M. Bhattacharya and an additional senior government advocate appearing for the state. In view of the above, this writ petition stands disposed of on withdrawal with liberty.
Obliged, your Lordship. 4, 5.
Why not 3?
Three as well.
Lordship in 3 Lordship 14.66%. And then in next is in Amlan Lordship 30%. 6 is Lordship 13%. And Lordship in 7 it is 30%. That's all.
Yes, my lord. Humble submission. Yesterday order, I know I have seen, my lord, your lordship. But my lord, here is the case. The apex court in my lord, before that, my lord, the government in exercising the power under section 56 notified the certifying authority, my lord, in the Joint Director of Health Services. And if anybody aggrieved by the certificate, my lord, the findings, then appellate authority is the director of a health service, my lord. I get the notification dated, my lord, 14. And subsequently, my lord, the notification, the OM, my lord, it is a mere guideline of the executive instruction, my lord. And they have constituted an appellate authority, like, my lord, over a statutory body, my lord. My lord, and the executive exercises that power, my lord. My lord, in exercising of the power, my lord, section 3, subsection 3 of the Right of Person Deteriorated 2016, my lord. In section 3, subsection 3, non-discrimination right has been given, my lord, subject to limitation, my lord. And in section 20, my lord, there is also given a right, my lord, the non-discrimination in government employment, my lord. By interpreting the section 3, subsection 3, and my lord, section 20.
See, Mr. Roy, the point is, since they've conducted a medical reassessment, the findings will have to be challenged, obviously, because now they find that your client does not meet the benchmark.
Yes, my lord.
But you can't challenge it unless they communicate it to your client. Only when they communicate a new challenge, then we'll call for the records, right?
Yes.
And of course, the other ground will be, is it permissible to re-verify? The answer in all probability will be yes. Because if the authorities want to check whether the certificates are based on proper ground or not, then the court cannot say that, no, it's arbitrary. But all this will depend on what transpires from the record. If you do not challenge the findings, then your clients will be handicapped. Of course, your clients will be handicapped. So later on, you will have to withdraw the writ petitions and file a writ. Whether you want to do it now or later on is the only issue here. From the experience of the court, I'm saying these things. You want this, we'll admit it, issue notice, they'll file affidavits, but those will be heard in usual course. But they will always say that your disability is far less than, and you will not be able to argue or assail that because you don't even know what is your disability. There is no pleading to that effect. You have to take a call. A legal issue will be decided in due course. But the point is, there are findings of a medical board constituted specially for this purpose. If the finding is right, there is no question of any immediate relief. If the finding is wrong, we'll assess it from the record, then of course the matter is different. Therefore, you have to decide what you want to do. Arguing a case is okay. You can argue. We'll fix it for hearing in usual course. Is that what you want? Then we'll do it. But obviously there can't be any interim order. Question doesn't arise. So you argue, we'll issue notice and ask them to file affidavit.
And my
Hmm?
yesterday's order,
Sorry,
then my lord, yesterday's order will cover.
you can't help it. They are raising, you see, doubt over your status as a PWD candidate. And that is based on some finding of a medical board. Unless that finding is assailed, how can you get relief? Your clients can't get relief in any of these cases.
But my lord, in Vikas Kumar, my lord, Apex Court held, my lord, the concept of benchmark disability. My lord.
You don't even know whether you fulfill the benchmark disability or not. It is his oral some
No, no.
instruction only.
Yes, oral submission, but
So then we'll admit it. And it
my
will
lord,
come in usual
yesterday's
course.
order, my lord,
Huh?
within
15 days.
15 days, my lord, can provide.
Which are the
Okay.
cases? No, don't feel pressure. You can take your stance. If you want to argue on merits, then I'm willing to hear you. You can argue. But then after you argue, I'll pass the order which I think is correct. And we have to admit it. And we'll post it for usual hearing. That's all. You can't get an interim order after this. That's it. That question is out. What do you want to do? You decide, Mr. Roy. If you want some time to decide, that's also okay. You want half an hour time to decide?
No, my lord, yesterday's order, and
Lordship 7099 of 23. Yesterday's. Item number 4.
Okay. Which are the items to be listed? 3,
Lordship today 3, 4, 5, 6, 40 and 41.
3, 4, 5, 6, 40, 41.
3, 4, 5, 6, 40, 40.
So same order as yesterday's case. All
Yes,
disposed of. Within 15 days, give it. Let them raise this question.
Yes, sir.
But obviously,
but
you will have to satisfy the court if they challenge it, that why did you ask for reassessment and why was it only for some candidates? Have you done a reassessment for everyone? Otherwise, we'll set aside the entire appointment process.
Highly obliged, Lordship.
Ali order, same order. Who are appearing, just give the appeal.
Item 7 and 8.
My lord, this matter may be taken up after some time. He is in legs in court number 3, lordship.
No, 8, he is asking for adjournment.
But lordship, we have some urgency in this matter. Can it be
Alright.
taken up after some time?
All right, passed over for the time being.
May it please your lordship.
Yes.
My lord, this is another attempt by the state respondents to overreach the order of this honorable court. In regard to our date of birth, my lord, we came before this honorable court and this honorable court was pleased to pass the order at page 54. The operative portion is at page 55. This was an agreed order of the councils for both the respondents and accordingly this order at page 55 was passed.
Yes,
Yes, so what is the controversy?
Now, as per this order, the agreed date of retirement was 31/3/2023. Now they say at page 66 by the impugned order passed by the respondent number 2. They have observed, your lordship will, they have observed this, perused these documents from 1 to 20. Then the observation is at page 67 up to, my lord, page 70. Your lordship will see the matter for consideration at page 70. Especially, my lord, clause 7. Basically, what they want to say that my date of retirement ought to have been 31/2/2022 instead of 31/2/2023, but 31/3/2023. But as per this service book, my date of retirement ought to have been 31/3/2025. Since there was this confusion in regard to the date of birth, that's why we came before this honorable court, and it was an agreed order. Since our retirement benefits were not paid, we filed a contempt. Then this impugned order at page 70, they say that not only I have to refund the money, which is for no fault of my fault or any misrepresentation on my part, they have also forfeited the promotion that was given to me during the period from 31/3/2022 to 31/3/2023.
Yes, what you will stay this order.
My lord, we are processing his pension claims. My lord will see, my lord will kindly come to page 55. My lord had expressed no opinion on the controversy, my lord, as regards date of birth. And as I can recall, my lord, his date of birth was rectified by at the very fag end, my lords. So my lord will process his pension benefits, my lord, and
No,
in
but
other case will file affidavit.
he has worked up to 31/3/2023,
Yes, ma'am.
is it not? He has
Yes.
worked. That's your own showing.
He has worked, my lord.
So having made him work, how are you going to recover that amount? Then
My
give him back his time.
That my lord can interfere, but my lord, because my lord, there is a investigation is to be conducted, my lord. This vigilance department has been moved as regards the controversy regarding his collection of date of birth. That part will file affidavit, my lords, and will process his pension papers. If recovery, my lord is willing to stay, my lord.
Stay the recovery, that's all.
Recovery and, my lord.
No, that part has to be seen. That has to be looked into.
Recovery and
that they have also forfeited the promotion given during this period. They want to calculate the my pension in regard to the date prior to my promotion, my lord. That they can't do it, my lord.
And the recovery part, lordship, that is okay,
Recovery,
my lord. But
recovery
that-
and
no,
they
my
will
lord.
not pay it, my
No,
lord.
my lord, that promotion part we have to look into. my
Please,
lords.
let me clarify to the
That
court.
promotion part we have to look into, my lord. That is the investigation being conducted.
No, but you have forfeited it. Now you look into it.
Huh.
You have
Forfeited
killed him
means
and
stayed,
then
man.
you will decide whether he should
No,
be.
I will reply that by affidavit. my lords. This
is
person is, my lord, no, I won't comment, my lord. This person, my lord, normally
No,
he,
this person may be good, bad,
Yes,
ugly,
sir.
we don't know.
recovery,
But-
my lord, can interfere.
But because he is bad,
Uh,
you also can't be bad.
yes, my lord. No,
Is it not?
we'll reply
Are
by
you going to
affidavit. my
also
lords.
behave like him?
No, no, no. Well, we
My
did
lord,
a very short
Prima
time, my lord.
facie, my lord, this order is not in consonance with law. And so prima facie, since your lordship is satisfied, if your lordship is satisfied, your lordship will stay till the next date. And so far the pension and other benefits, they want to calculate it prior to my promotion. I did not take the promotion by any misrepresentation or by fraud. It was a due promotion. Since I was working, I got the promotion. Now they said that no, you will not be given the benefits on the basis of your.
Once you give a promotion, how can you withdraw it? How can you
Well, that
withdraw a
check
promotion?
will reply, my lords. Will reply. Short date may be fixed, my lords. Will reply.
Then we'll have to stay the whole order. Heard Mr. B.D. Kondal and Senior Counsel listed by Mr. So H. Agarwal, Learning Counsel, appearing for the writ petitioner. Also heard Mr. D. Gogoi, Learning Standing Counsel, Forest Department, Assam, appearing for the official respondents. The order dated 5/12/2023 passed by the Under Secretary to the Government of Assam, Environment and Forest Department, has been essayed in this writ petition on numerous grounds, including the ground of being in contravention of the letter and spirit of order dated 28/7/2023 passed by this court in WPC number 3642 of 2023. Mr. Kaur submits that the department having agreed to the consent order dated 28/7/2023, they could neither have ordered recovery of any amount from the petitioner for the services rendered during the period from 1/4/2022 to 31/3/2023, nor was it permissible to forfeit the promotion given to the petitioner on the grounds stated in the impugned order. Under the circumstances, a prayer has been made to stay the operation of the impugned order dated 5/12/2023. Mr. Gogoi, learned Standing Counsel, Forest Department, Assam, submits that there are serious anomalies raising suspicion about the circumstances under which the age of the petitioner was corrected, and therefore the matter calls for appropriate inquiry by the departmental authorities. So, the learned Standing Counsel, Forest Department, Assam, submits that in 4 weeks from now, an affidavit will be filed bringing all relevant facts on record. An affidavit will be filed on behalf of the department bringing all relevant facts on record. In view of the above, issue notice of motion returnable in 6 weeks. Since Mr. Gogoi has appeared and accepted notice on behalf of respondent numbers.
Minus 1, 2, and 1, 2, 3, and 4 minutes. Let it be 4 weeks and a fixed date, minutes. Let it be 4 weeks at a fixed date.
4 weeks. 1 to 4 and Miss. And Mr. R.K.
Likhit.
Talukdar, learned Standing Counsel, AG Assam, for respondent number 5, service of notice deemed to be complete in this case. The copies of the report should be furnished on behalf of the furnished to the learned department council so as to enable them to obtain instruction. Heard on the prayer of interim relief, having regard to the facts and circumstances of the case, it is hereby provided that operation of the impugned order dated 5/12/2023, insofar as the same relates to forfeiture of promotion given to the petitioner to the rank of promotion to the rank of
ACF.
SCF, and also the direction for recovery of pay and allowances drawn by him during the period from 1/4/2022 to 31/3/2023 shall remain suspended. The departmental authorities would, however, be at liberty to proceed with the other other conditions stroke observations made in the impugned order dated 5/12/2023.
My lord, they will take the plea of sub judice and not pay me
No.
my
Including-
petitioner the pension in another
Processing
data.
the pension of the petitioner.
Process. Well, the date, 4 weeks a date.
Make it returnable on 24th of January.
My lord, 24. Obligation.
May I please, my lord?
Yes.
My lord, also the petitioner applied for the post of Anganwadi worker in that particular center, my lord. And the private respondent had been selected, my lord. But by an RTI, my lord, I got the application form of the private respondent, wherein she applied for the post of Anganwadi helper. But page 35, my lord, is the application form of the private respondent. Now, my lord, the government has filed an affidavit on behalf of the CDPO, my lord. She has said on the same day, my lord, she had filed another application for correction of this, my lord, application form. That is the statement of the, my lord, CDPO, but she has not submitted any documents to support that, my lord.
1 minute. So is the respondent number 6 served?
Respondent number
As per
6
the earlier order, it was served.
is not appearing.
And department has filed affidavit.
Department is-
I filed the affidavit.
So ready
It may-
for
Yes, Lordship.
final argument today?
Yes, Lordship. No, Lordship, it may be fixed for hearing, Lordship. pleadings
What
completed.
hearing?
Lordship.
This small matters, what hearing? We'll finish
Lordship,
it off today itself.
But so far, he stated that we had not submitted the
Oh, you,
record.
are you ready for final disposal today? I'm asking
The
you.
record is necessary, Lordship, here in this case. To establish the
What
fact,
record is necessary?
establish the fact that the petition,
You are also not ready.
I'm ready, my lord, otherwise.
the respondent, he stated that the respondent, the review petition, the review application of the respondent is not annexed in my affidavit, Lordship. I have to produce that.
Oh,
record.
whatever is there is there. How many times you will do it?
No, and after vacation, Lordship, I will.
Then let them produce the records by the next step, my lord.
Heard Mr. J. Pang, learned counsel for the petition, also heard Mr. J. K. Goswami, learned additional senior government advocate, Assam, appearing for the respond numbers 1 to 5. None has appeared for respond number 6 despite service of notice. This matter can be taken up as per the submission made at the bar. This matter can be taken up for final disposal at the stage of admission hearing. However, the perusal of the records would be necessary. In view of the above and on the request of Mr. Goswami, register to list this case again on 10/1/2024 for admission as a fixed item. On the next date fixed, the learned departmental counsel to produce the records.
Item 14.
My lord, they have to file an affidavit. My lord, the date may be fixed before or not. If person was, my lord, denied lien, my lord.
We'll file our affidavit, my lord. I'm appearing on behalf of B. Gogoi, my lord.
That's all you have to submit, that you are appearing on behalf of B. Gogoi.
We'll obtain our instructions, my lord. We'll file our affidavit.
Is there any interim order?
No, my lord, no. There's no interim.
So how much time you want?
After the vacation, my lord.
After vacation, Mr. D. Gogoi, learned counsel for the petitioner is present. A request has been made by the learned standing council, finance and taxation department, Assam, appearing for the respondents to adjourn the matter for 4 weeks so as to enable him to obtain instruction and file affidavit. If the prayer is not opposed, same stands alone. Let this matter be listed again in the 3rd week of January 2020.
I'm preparing for respondent number 3 and 4, RB Goswami.
Your name, please?
H. Purva.
Mr. H. Borua for 1 and 2 and Mr. R.B. Goswami for 3 and 4.
Okay.
These cases are filed, my lord, regarding selection and appointment of my lord, regular basis Gaura, my lord. There are, my lord, all pleadings part have been already completed, my lord. And my lord, thereafter, my lord, matter has been listed before your lordship. The independency of your lordship order, my lord, operating when your lordship order was operating, suddenly they have published another advertisement. So I have to file, my lord, we have to file, my lord, this separate petition again, my lord.
1 minute, 1 minute. So what has happened when this order was operating, they issued another advertisement.
Another advertisement, that's why I have to file, my lord, another petition 1954. Here also my lordship order has been in annex here, my lord, page 54 in an earlier case. And subsequently, case is pending. There is an interim order also, my lord, operating. Similar. And that's why, my lord, it has been on admission test, it has been listed today, my lord. So, my lord, after vacation, my lord, your lordship,
What is wrong with before vacation? Everybody wants after vacation.
I have to go, my lord. Otherwise, I am ready, my lord.
Argu, yes.
Yes, my lord. After the lordship order, my lord, as your lordship already passed order, my lord. Thereafter, they have published another advertisement.
No, that comes later. What is the facts? What
Yes,
is-
my lord.
what
Facts
you-
of the case is that, my lord, like that, my lord.
Hmm.
In the year 1996, they were appointed, my lord. Petitioner number 1 reflected in page 26, annexure 1. Kohinoor Ali, my lord, he was appointed 28 March 1996. Thereafter, annexure 2, in the interest of public service, persons hereby appointed as purely temporary basis. This petition number 2, Hasan Ali, he was appointed in the year 1993, my lord. Thereafter, what is happened, my lord? One government notice was, my lord, the notification was published in the year 2009, annexure 3, page 29. We were saying that with regard to
You are
absorption.
arguing from which case?
Well,
Which
I'm
petition?
arguing this, my lord, 1954, WBC 1954-22.
Item C.
Yes. Page 26.
Yes, my lord. Starts from page 26.
You must tell the court which matter you are arguing.
Yes, I'm sorry, my lord. Possibly, I think the body matters.
Yes, this is not legible, but yes, what do you want to show?
In page 26, annexure 1 is the appointment letter of the petitioner number 1. With great pay, he was appointed as additional mandal by the settlement officer then, my lord. Thereafter, annexure 2 is the appointment letter of the petitioner number 2. He was appointed 21st September 1993. 27 page.
So these appointments are based on what? Some regular selection?
No, my lord. Appointed purely temporary basis, they were appointed.
So
But I
suddenly,
guess,
some people are called and appointed.
yes, my lord.
Now you want that they should be regularized.
No, my lord, what is, they have already picked, adopted, my lord, already taken steps by the government in 2009 also, because as they were working since long back, they are to be absorbed in regular basis, on regular basis. And in the meantime, my government adopted that decision, my lord. After taking that decision, they have already my lord, sent some of the additional model to different district also, my lord. In this way, they were regularized, my lord. Subsequently, my lord, another order my lord published, my lord, page 31, annexure 4. This order, in person to government letter dated so the service of the following mandal parties who are working under the settlement resettlement operation are absorbed against the vacant post of Lord Mandal under the establishment of deputy commissioner as shown against the absorption, against their name, my lord. And petitioner, my lord, this petitioner number 1 and 2 were accordingly absorbed, my lord, in 2009 itself, my lord, by the order. Page annexure 5, page 32. 32 and 33. And subsequently, my lord, redeployment of the additional mandal who could not join in the respective post of mandals, they were again revert back to additional mandal, annexure 7, page 34. Thereafter, one modifying order has been passed, my lord, by the Director of Land Records, annexure 8, page 36, saying that, my lord, in modifying the earlier order dated 25/9, the services of the following additional mandal patoaris who were working under the settlement resettlement operation, who were absorbed as mandal under the deputy commissioner establishment and could not join in their place of posting are hereby redeployed to original post of additional mandal patoaris under ongoing respective settlement operation, file letter dated 1/6/2009.
Accordingly, my lord, annexure, my lord, 9, page 37. This order has been passed by settlement officer, wherein petitioners' names are here, my lord. Serial number 10 and 24. In partial modification in continuation of to this earlier office order dated so and so, and in the interest of public service, the following temporary additional mandals are hereby directed to report to the ASO as shown against their names to complete their residual works in the connection with the closer ongoing resettlement operation in PS area of Gwalpara and Bongaigaon district. They are directed to report to their circle on or before so and so. Yes. Thereafter, my lord, one repetition was published, my lord, because another, my lord, in the repetition, my lord.
Repetition
order-
was published.
Lordship?
Repetition was.
No,
pub-
my lord, repetition, my lord, repetition was filed, my lord.
Hmm.
One repetition was filed, wherein, my lord, that order was 12/6/2015, my lord.
Hmm. Yes.
There is an observation, my lord. In that order, my lord. He submits that petitioner submits the covered by the judgment dated so and so, the relevant portion. There are numbers of cases in this way filed, my lord. Ultimately, my lord, one, my lord, order was, my lord, filed in the year 2000, my lord, one repetition was filed in the year 2017, as there was one advertisement was published, my lord. In that advertisement, that order has been, my lord, that advertisement has been set aside, my lord. Page 96, my lord. So 46, page 46. The relevant portion 46. Paragraph 11 onwards, my lord. It is stated at the bar that there are numbers of regular vacant posts of Lord Mondal in Gwalpara district, which is more than the number of petitioners hearing. The apex court in the Umadevi Supra has been given a direction to the Union of India and the state government to take steps to regularize as one-time measure the services of irregularly appointed persons who have worked more than 10 years or more, provided they fulfill the condition enumerated in paragraph 53 of the same not having been done in respect of the petitioner herein, the state governments are bound to consider the case of the petitioner for regulation as a one-time measure. Accordingly, in view of the above reasons, the state governments are directed to consider regulation and absorb the petitioners in the regular post of Lord Mondal available in the Gwalpara district with respect to those petitioners who have not retired as on date. The entire exercise should be carried out within a period of 3 months from the date of receipt of the certificate copy of the order. Until then, the state government respondents are also directed not to give effect to the advertisement dated 14/12/2015 till the writ petitioners are considered for regulation absorption and a decision taken in that respect by the state government respondents. That order was passed. Accordingly, petitioners, my lord, submitted representation before the deputy commissioner, my lord.
They were also appointed as additional Latmandals for Gwalpara.
Yes.
These petitioners in this writ petition,
Yes.
WPC 6120.
Yes, they are also here. They are also here. 6120.
8004.
8004, yes, my lord. Hassan Ali petition at serial number 4, and this petitioner, petition number 2 at serial number 8.
So then there is already a direction.
Already direction. In spite of that, their advertised published, my lord, we participated as to lordship order. We have already participated, but we could not be able to succeed, my lord, in the interview, my lord. Because, my lord, as we were all persons already most of 5 years to retire, my lord. But already as our colleagues have been already, my lord, given that but adjustment order, my lord. But just we remains 2, my lord. And this after the lordship order, my lord, this advertisement again published to, my lord, fill up the 8 posts, my lord, in Gwalpara district, my lord. And hearing.
So how this order has been complied with 6/12/2017, Mr. Hendik? Page 42.
1954.
Lordship, what happened, Lordship? Earlier occasion, there are several writ petition has been filed. By the, on that time, the additional Monroe and Patuaris, Lordship. Accordingly, Lordship, may kindly see the annexer A, page 8, in my affidavit, Lordships.
So we'll come to that.
Lordship.
What do you have to say on this order, 6/12/2017?
My lord, that's why, my lord, that I have, my lord, that annexer A, page 8, Lordship, my lord, page, my lord, in my affidavit 13, my lord, it was not brought to the record, my lord, in the, before the court, Lordships. There is a review petition, my lord, regarding, my lord, after the, my lord, that orders, Lordship.
Review against this order.
My lord, there are several orders, Lordships. I have, my lord, that Lordship, I can see the, my affidavit, Lordship.
No, Mr. Hendrick, please answer the question.
Lordship.
I'm asking, is there a review petition pending against the order dated 6/12/2017?
Lordship.
Yes or no?
Lordship.
Yes, give the number, review petition number.
1/2013, Lordship. My lord, 2013, that order, Review.
2013.
Lordship.
You preferred a review petition in 2013 against an order passed in 2017?
No, Lordship. This was not, my lord, in a review petition, my lord. It was, my lord, writ petition number 892, 2011, Lordships.
So in this writ petition, this order, these petitioners were also petitioners here. The
Lordship.
court has directed that they should be observed, regularized.
That's why, my lord, I was saying, my lord, that there is a, my lord, review petition was directed, my lord, some, my lord, accordingly, my lord, that office memorandum has been published. Some condition has been given, Lordships, after the review petition, Lordships.
Some bureaucrat has set aside the order of the High Court.
My lord, this order, my lord, according, my lord, this report, my lord, that order, Lordships.
But the secretary set aside the order of the learned single judge or modified it.
But this is not been modified, Lordship. The 2017 orders is still there, Lordship.
Then why they have not been regularized, observed?
My lord, in pursuant to the, my lord, that office memorandum 2013, my lord, there is a condition, my lord, that they have, my lord, those who are the absorbed, my lord, or serving as a, my lord, additional Patwari or Mondal, Lordship, they have to apply to the, my lord, that post when the advertisement of the public.
No, why we are asking you is just to decide, we'll draw up suo motu contempt against the officers. Why? Because there is an order of the court. They have ignored this order.
Lordship.
So you agree that they are in contempt?
My lord, that order, my lord, regarding, my lord, this 2007,
I
my
think
lord.
you are not understanding the importance. Probably you have not. read the
Lordship,
brief.
I have.
We'll pass an order in next 5 minutes. There is a direction from the learned single judge to absolve the petitioners, which includes the present two petitioners. Direction was passed more than 5 years back,
That is true, Lordship.
6 years back. Why this order has not been complied with? And why have you not filed any contempt case, Mr. Das?
Lordship,
Why have you-
matter was, we submitted representation before the authority, my lord. But subsequently, they have published another advertisement, my lord. Matter was remains, my lord, without any order, my lord. Subsequently, my lord, another advertisement published, we, my lord, challenge before your lordship, and your lordship
Then
passed.
we'll hear it in usual course. There is no urgency.
But
You get an
otherwise-
order from the court, you don't try to get it implemented. You file one petition after
No,
another.
even after lordship order also, they have published another
They
advertisement.
will. There is no stay order.
Yes, my lord, in spite of lordship or observed, they are, the two participate another in the interview, my lord. Thereafter, another advertisement published.
Lordship was on that order was passed. My lord, that before that, my lord, this order was passed, they already been, my lord, they selected and appointed Lordship the person.
And some persons selected, but
They were also, my lord, asked to appear in the interview, my lord,
we
but
participated.
they did not apply to Lordship.
No, applied, no, we participated and failed in
So
the.
there is no contempt of court.
No contempt case has been filed. ma'am.
I can see contempt on the face of the record.
Yes, I
Mr. H.
filed.
Pradhan, counsel for the petitioner also, Mr. J. Leonard, SC Revenue Department also, and Mr. J.K. Goswami, Leonard, additional senior government also hearing for the response.
Yeah.
After hearing the arguments advanced at the bar, this court is of the opinion that the issues raised in these writ petitions will call for detailed hearing. As such, admit the writ petition Since the respondents are already represented, no formal notice is required to be sent. Yes. Extra, no, register to list these cases for final hearing in the second week of March 2023 as fixed items. Parties to exchange pleadings in the meantime is said. You have not pursued the matter properly. There is already a direction to observe you and.
Yes, my lord, we have
We will
mentioned it.
not pass another order, same order. There will be no further direction to observe you. You have slept over your right, it is gone.
No, my lord.
We want to say that in March, not in December. That's the only difference.
But they have processed, my lord.
What process? The court has directed that
Yes, my lord.
regularize. Why have you not come to the court seeking implementation of this order?
On that time. they
Same
have to-
order will not be passed twice. That's not permissible.
My lord, I'll satisfy, my lord.
Wait, please, yes. Lord, I know, my lord, on a here, my lord, 3 days before vacation, lordship is taking up this matter. My lord, some urgency on the part of the petitioner.
Argu. 3 days, 4 days, 3 hours doesn't matter.
My lord.
You
My
are
lord,
ready to
petis-
argue.
issue is involved in this writ petition is that, my lord, petitioner is a professor under Omiya Kumar Das Institute of Social Change and Development. And state of Assam, by way of a cabinet decision, has raised the age of superannuation of all professors to the age of 65 years. But that benefit of 65 years of age of superannuation is not given to the petitioner. The stand taken by the respondent authorities in the form of affidavit is that the institute is not an educational institute, rather it's a research institute. And the controlling authority is not the higher education department, it is by transformation and development department. Therefore, the notification which was issued by the education department raising the age of superannuation is not applicable to the petitioners. That is precisely the issue involved before your lordship, my lord.
Just
And-
1 minute. Just one. Please take your seat.
My lord.
The petitioner is still in service.
Still in service, my lord. He will retire on in the month of February this next year, my lord. He will attain 60. So he'll be 60.
Where is the cabinet decision?
Lordship, that
Our affidavit, Lordship, kindly see our additional affidavit. Additional affidavit filed on.
my lord, cabinet, the notification pursuant to the cabinet decision is at page 78, my lord, annexure 7
Read petition, no?
of the writ petition, my lord.
Our additional affidavit also, we have annexed it.
Additional affidavit dated?
Dated, my lord, it is recently we have filed it, my lord. On, my lord, it's November, 15 November 2023. Additional affidavit filed by the, my lord, respondent number
423, 440.
3.
Page number.
I have extra copy, Lordship, and see. Additional affidavit লাগিব আমার।
On page 423. It will be here only. Next page, next page, next page. Yeah. Yes, which page of the additional?
Page,
affidavit?
last page, my lord. Page 235, 36 running page, my lord. Last page. Extract of minutes of the cabinet meeting held on 19/9/2012. My lord, item number 1, raising of retirement age to 65 years. It was decided to raise the age of retirement of all professors of educational institutions, including medical college, to the 65. Educational institution only, not research center or like that, my lord. This is a government policy that they have admitted it. They have filed a affidavit reply in the earlier affidavit. They have annexed here. Lordship, kindly see the affidavit reply filed by them. They have annexed as heard 24 institutes in India, like Omyokuma. In the Northeast, only Omyokuma, and 24 are there, but 23 are there. All are age, retirement age is different. Some 62, some 60, some 65, like that. The state government's prerogative.
1 minute. So how many institutions are there like Omia?
24.
24.
In India.
These institutions, the professors, what is their age of
May I
superannuation?
intervene? my lord?
60 years.
May I intervene for a minute, my lord? Lordship, there are 24 institutions which are funded by ICSSR and respective state governments, out of which, my lord, there are 4 institutions which are 100% funded by ICSSR. In those
ICSSR or ICR?
ICSSR, my lord, Indian Council of that, my lord, they are funding these research institutions. In those institutions which are 100% funded by ICSSR, their retirement age is 65 years. And there are around 20 institutions which are co-funded by ICSSR and the respective state governments. In those 20 institutes, the age of superannuation of the respective state university is followed. That is precisely the case of the petitioner. My lord, in respect of any other state, Lordship,
So those facts are on record?
yeah, those are on record, my lord. So,
Where have you stated?
Lordship, Lordship, may kindly take out the reply affidavit, my lord, which has been filed by the petitioner to the affidavit in additional affidavit filed.
Well, last date, my lord, an amicus was appointed by this honorable court. Amicus to ki naam asil? Chakraborty. Oh, Chakraborty.
Lordship, otherwise,
Yes, Chakraborty.
Lordship, kindly take up page 460, my lord.
1 minute, 1 minute. Think some amicus curiae was appointed, is it correct?
Yes, my lord, honorable court on the last occasion appointed, my lord. But otherwise,
Earlier occasion, my lord, Justice my lord, A.K. Nair was at the council after elevation. UK Nair, my lord, after elevation, my lord, court last date appointed an amicus curiae, Chakraborty.
There is an amicus appointed, then
Lordship will hear the amicus, my lord. Lordship will take up at least the documents, my lord, which are apparently clear. If your lordship thinks that.
Today we'll pass the order and hear the amicus later on.
No, my lord, I'm not saying that. Lordship will kindly just two documents I will place before the
So
lordship.
what is the purpose of hearing it today then? Where is Mr. S. Chakraborty?
I'll call him, my lord, after some time. my lord.
Call him.
Supervisor.
Call him. If he's ready today, we'll hear it. Otherwise, we'll
I'll-
fix a date.
After some time, my lord, I'll call him. then.
Yes, yes. Please wait. His name is not shown in the cause list.
His name is shown, my lord.
Shown.
Yes, my lord.
Then why has he not appeared?
Item number 17.
His name is shown, my lord. I'll call him. my lord.
Call him.
Matthew. Something.
My lord, the petitioners are casual employee. They are working for more than 30 years, 40 years, 26 or 27 years like this, my lord. And they are getting only a fixed minimum wages of this 9,000. Earlier they were getting 900. While they receive daily wages of this 200. Like this, the entire stream of life they have spent in rendering services as casual employees under the Social Welfare Department. And their services are not yet regularized. In the meantime, government have decided that all workers, master and casual employees who have rendered services for more than 10 years or more will be getting a minimum pay scale of rupees 15,900 plus DA and plus 300 medical allowance as monthly. But these 13 workers, casual employees, are not listed in the list prepared by the Finance Department. Finance Department have prepared a list of all the workers and master role and casual employees of the state, of all departments, my lord. But in their cases, it is told that the Social Welfare Department delayed in submitting the list of their employees in Finance Department. And that is why their names are not enlisted and they are being deprived from the benefit sanctioned by the government. In the meantime, the finance are rejected that your claim for is rejected because you have delayed. But delay is caused not by the employee, my lord, not by the workers. Delay was caused by department itself. But now the finance department is telling that their cases were received after sunset clause. What is sunset clause? Sunset clause, sunless court, and they have told that henceforth no any additional list will be accepted or new list will be accepted. But this is not a new list. This was submitted on before in 2001. That has been agreed. Finance agreed, my lord. Yes, like this. I am reading one. My affidavit against the affidavit I have submitted. I am reading. Para 13 of additional affidavit. Here it is, I have mentioned that in paragraph, in the subparagraph 3 of paragraph 8 of the affidavit in opposition, the deponent, respondent number 3 has agreed that the proposal in respect of the petitioners along with other similarly situated casual workers was submitted by the Social Welfare Department in the year 2001. In file number LWD one CID, but without prescribed checklist. Height endorsement dated 4/10/2021. Social Welfare Department was first requested to resubmit the proposal along with information as per Finance Department letter number so and so dated 9/10/17, along with proper justification for submission of proposal since it was submitted after a gap of many years. The Social Welfare Department is stated to have submitted their proposal along with checklist in Excel height number as the minimum for minimum pay scale of 45 numbers of incumbents. The proposal was received after sunset clause. Sunset clause means 16/9/2021. My submission is that they do not accept any new proposal, additional proposal, but it is not new or additional. It is the original proposal which was under consideration. And Finance Department was considering before the sunset clause. And they were requested, Social Welfare Department was requested to resubmit the proposal in the proper form. That means proper form is a list, a form prescribed by the Finance Department.
Lordship.
But they submitted the proposal in their submitted the proposal in a form prepared by themselves, because if there is a list prescribed by the Finance Department, it was not necessary to submit the list in their own form. That is why the matter is evidently it is established that the matter was under consideration before the sunset clause was imposed. There is one matter. So matter was considered, but they have rejected. Now question is that, my lord, whatever may be, they are the poor employee. During the entire life they are serving, they are under starvation. They are feeling troubles. They are poor men. The department have committed a wrong committed by some other person, some other authority. Why the innocent person should be suffered? Their life will be spoiled. Their children, they have children. They are at the end of retirement at this age. At this age, if they are deprived, then what will be fate of their family members, their children, their family, etc., my lord. So they are not responsible. They are ignorant about what is the fixed death, what are the sunset clause. They do not understand what is sunset clause. And they are not concerned to that point. They are not informed anybody by anybody that your submission of list is delayed. So you cannot get that like this. No any information was given to them. So the persons, more illiterate person maximum, the persons who are innocent, who are not guilty, who are working since last 30, 40 years ago, how could they be deprived? And the letter issued by Finance Department is mandatory, not mandatory. It is the Finance Department who can amend it. It is the interdepartmental understanding, my lord. That matter was under consideration. So they may be included. This is not a new proposal, not an additional proposal. It was being considered, but not in proper list. This is my submission. What my friends say, I shall again submit if necessary.
Lordship. Lordship, so far in the earlier order, Lordship, he is seeking time for filing the specific reply against the affidavits submitted by the respondent, Lordship. But that reply was not received by us, Lordship.
It appears, Lordship, on 15/12, one reply has been filed, Lordship, but copy is not with me also.
We'll dispose of this matter today. You can make your submission. You can make your submission and
Have one opportunity to go through that dialogue.
go through it. At 12 o'clock, we'll take up.
At 2 then, Lord.
If the matter is over, then I will not sit. Go through the reply, it's in the record, give it to it. At 12, we'll take up this case. Call the next matter.
Extra copy,
No, civil.
Please, your lordship, on the last occasion, status report was called from the respondent.
Lordship, I have got an updated status, Lordship. Where the Labor Commissioner has been requested to provide the movable and immovable properties, Lordship. এই assistant labor commissioner. List দিব লাগিব তাৰপিছত attachment.
No, Assistant Labor Commissioner has been requested.
Yes,
When?
Lordship. It was on 30th November, next page, Lordship, one petition is there. And I had a personally, I have talked to Deputy Commissioner, Lordship. I have requested him to expedite the matter as this.
All right, we'll call for a detailed report from the District Commissioner. to be
Lordship.
Placed on record on 30th of January.
Lordship.
Stating the progress made in the matter.
Lordship.
That report will be placed through you.
Lordship.
We're making that clear.
Lordship.
Heard Mr. A. Kakotil, and counsel for the writ petitioner, also heard Ms. M. Bhattacharya, learned additional senior government advocate Assam, who has obtained instructions in terms of the order dated 1/12/2023 passed by this court and placed the same before the, placed the same for perusal by the court. From the written instruction dated 13/12/2023 issued by the District Commissioner Tinsukia, it appears that the Assistant Labor Commissioner Tinsukia has been asked to take further action in the matter. However, there is still no clarity as to the progress made in this case for recovery of the amount due and payable to the petitioner. In view of the above and on the request of Ms. M. Bhattacharya, learned additional senior government advocate Assam, this matter is directed to be listed again on 30th of January 2024 as a fixed item. By the next date fixed, the District Commissioner Tinsukia shall submit a report to the additional senior government advocate Assam, indicating the progress made in the matter for recovery of the recovery of gratuity amount due and payable to the petitioner. A copy of this order be furnished to Ms. M. Bhattacharya, learned government advocate Assam.
Deeply amazed, Your Lordship.
May it please, Your Lordship.
Yes.
Your Lordship, this writ petition is pertaining to non-consideration of my promotion from senior assistant to head assistant post.
In which department?
In the Department of this Deputy Commissioner Kokrajhar, District Commissioner Kokrajhar.
LDA is equivalent to senior assistant.
NDA is equal to senior assistant.
So
Now-
consider him if he is eligible under the rules and if vacancies are available, consider. What is your stand?
Lordship, you filed a affidavit, Lordship, and
Their stand is simple, Your Lordship. They have stated that the selection committee could not hold any meeting. And since
Lordship,
2000.
since 2019.
Why?
Lordship, that period, Lordship, for COVID, Lordship, for that period.
Where is the statement? COVID?
Paragraph 11 of their affidavit, Your Lordship. Paragraph 12.
Well, but regarding the present status, Lordship, it was of August 2023, Lordship. That instruction. And since they were not coming, Lordship, on 2023 only, they filed the petition, Lordship.
No, no.
What
we
is the
filed
criteria for promotion?
Your Lordship, first in the feeder post, we have to serve for 10 years. And thereafter,
Where, under which rules?
under the Lordship, under the Assam Ministerial District Establishment Service Rules.
Show me the rules.
Your-
Is that the rule applicable? Assam ministerial establishment?
Six, first page, second page. Has been highlighted, Your Lordship.
But you are a LDA.
No, I was promoted from LDA to senior assistant
When?
on 17/12/2007. Page 14, Your Lordship will find the order of my promotion. Thereafter, page 19, Your Lordship will find that I was recommended also by the official respondent. Thereafter, the respondent said that ACRs are necessary to be produced before the selection committee within a period of 1 month. From on 15/10/2019, they said that. But till that, from 2019 till date, they have not produced the ACR. Page 19. Then page 20, Your Lordship will find my representation, which I made on 8 March 2019.
Yes, so what do you have to say? We'll dispose of the matter. You are appearing for?
I'm appealing for the respond number 1.
What do you have to say?
Your Lordship, I'm for the actually the committee. As they have said, the ACR grading is done by the DC establishment section, so they are actually the relevant authority.
No, that we are not on a. Why
is it
has the petitioner been considered for promotion?
As far as we are concerned, we are not.
Right.
The main thing is the DC establishment is the answer. The ACR grading is done by the DC.
In the affidavit, nothing is mentioned whether he has been considered for promotion.
Lordship. Lordship may be allowed to take a
Time up. There is a limited time. Heard Mr. S. Daftar, learned counsel appearing for the writ petitioner. Also heard Mr. A. Phukan, learned standing counsel, General Administration Department, bracket GAD, bracket close. Government of Assam, appearing for respondent number 1. And Miss
2, 8 Talukdar.
A. Talukdar, learned counsel appearing for the respondent number 2. None has appeared for respondent number 3 since the post of Commissioner Lower Assam Division has since been abolished. First of the writ petitioner herein is serving as a senior assistant bracket UDA in the establishment of district commissioner at Kokrajhar. He was initially appointed in the said establishment as a lower divisional assistant bracket LDA against a vacant sanction post on 27/1990. Full stop. Thereafter, the petitioner was promoted to the post of senior assistant by order dated 17/12/2017. Full stop. Since then, he is serving in the aforesaid post. According to the petitioner, according to the petitioner, his case has not been considered for promotion to the next higher post of head assistant in the establishment of respondent number 2. Although although vacancies are available and the petitioner is eligible for being considered for regular promotion as per the rules. Mr. Datta submits that the Assam Ministerial District Establishment Service Rules, 1967 governs the condition of service of the writ petitioner, and as per Rule 6 bracket 2 of the rules, the petitioner is eligible and duly qualified for being considered for promotion to the post of head assistant. First up, Ms. Talukdar, learned GA Assam, has invited the attention of this court to the counter affidavit filed in this case on behalf of the respondent number 2 to submit that due to circumstances beyond the control of the authorities, no meeting for considering departmental candidates for promotion to the post of head assistant could be held. First up, however, the learned government advocate Assam has assured this court that necessary steps as per the rules will be taken, and if the petitioner is eligible for being considered under the rule, his case will be duly considered. First up, similar the stand of Mr. A. Fukan, who submits that A. Fukan learned SC GAD, who submits that it is for the district administration of Kokrajhar under the establishment of respondent number 2 take appropriate steps in the matter, and the GAD would have no opinion to render in this case. First up. Next, law is by now fairly well settled by long line of judicial pronouncements from the apex court that the right to be considered for promotion is a fundamental right. First up, if a candidate comes within the zone of consideration and fulfills the eligibility norms for being considered for promotion as per the rules, he/she cannot be denied proper consideration for promotion, more so when vacancies are available for being filled up by way of promotion. First up, in the present case, nothing has been cited by the respondents to show that the petitioner is not eligible for being considered for promotion, nor is it the stand of the respondents that vacancies are not available. It appears from the submission of learned government advocate Assam that due to the outbreak of COVID pandemic, no meeting will be held during the relevant period for considering the case of eligible departmental candidates for being promoted to the post of head assistant. If that be so, there is no discernible reason as to why such an exercise should not be conducted by the concerned authorities now, since the COVID phase is practically over. As such, without expressing any opinion on the merit of the claim of the petitioner for being promoted to the post of head assistant, this writ petition stands disposed of with a direction upon the respondent number 2 to initiate appropriate measures for constituting departmental promotion committee stroke holding meeting for consideration of the candidature of eligible candidates within the establishment for being promoted to the post of head assistant. The aforesaid exercise be carried out as expeditiously as possible, but not later than 6 months from the date of receipt.
Lordship, may I submit my motion?
What is it? What is it?
Lordship, it's a part of the instruction, Lordship, what I have received. But here the question raised by the Lordship that whether he was considered for the promotion, Lordship. His name is not here, Lordship.
So that's all right. If he's eligible, consider. If he's not,
Maybe he is not eligible, Lordship.
then don't consider.
Lordship.
The aforesaid direction would, however, be subject to the condition that the petitioner is eligible to be considered for promotion under the rules. Full stop. With the above observation, writ petition stands.
At paragraph 19, all the petitions have been either disposed of or dismissed. But one petition is pending. Your Lordship, please to see paragraph 19. Either WBC 6174, it has been disposed of. WBC 8377 withdrawn. WBC 195, this is pending. WBC 1004 2023, this is withdrawn. WBC 2962 23, that is closed. Only 195 2023 is pending. And in that case, your Lordship is to see order page 28. What order was passed? Page 28. 29. However, last paragraph, last but 3 paragraphs. Liberty is granted to the petitioner to challenge the selection of the respondent wife before the appropriate forum. In terms of that, he has preferred an appeal. Para 8, preferred an appeal before the Lower Assam Division Commissioner, which is pending, and taking the plea of the pendency of the 2 cases. But there is no retentive order. My appointment is stalled. That's why I am before your Lordship.
What is the ground of challenge?
Ground of challenge is there is no interim order, no restatement
No,
order.
why the respondent is challenging your appointment?
Appointment challenging because I have 3 children, which is not permissible. But I have stated in my affidavit in opposition that second child is a twin child. That is the reason. And that is not applicable in terms of that notification. Notification kotha? 185 আছে। In 195 2023, your Lordship, please কত এখানটা নোটিফিকেশনটা আমার রিসিপ্ট interim board এটা তো ওই ISO তো
So this 195, who is appearing for the petitioner? Why it has been tagged with this case?
Your Lordship has pleased
No,
to
but,
remember.
obviously, that's on somebody's request.
No, While I was moving this application on the other day, your lordship directed that it should be tagged with that one.
On my own. That means I know all cases which are pending here.
Well, your
Is it
lordship is
that?
aware, well, to some extent, about the Gawara matter, your lordship is to some extent.
So are you saying this WPC 195 of 2023 was directed to be tagged with this matter from the memory of the judge?
No, it was pending since. On my submission that he has filed about 5 petitions,
Hmm.
but 4 petitions have been either closed or disposed of. Only 195 was pending.
Achha, what has happened to the other matter? 8377 of 2022? No, not 83. There is no other matter pending, is it?
No other matter. Appeal in terms of the initial order in 195.
Initial order in 195.
195. It will be at page 28 of the Chohralis case.
All right, then we'll clarify that pendency of 195 has nothing to do with the.
Yes, sir. Pendency of 185 as well as in the appeal before the commissioner.
Appeal, they will expedite disposal within
Yes.
30 days.
Yes,
When did you prefer the appeal?
19-1.
19-1.
19-1. Yes,
Is it 19-1?
yes, 18-1 is the order. 18-1 is the order at page 29. In that-
Where is the appeal now?
Divisional commissioner is the appellate authority. Divisional commissioner is the appellate authority. Now,
Where is the appeal at the moment?
lordship, government will maybe.
So you don't know.
Lordship,
Take your seat.
after.
I know all these things. Where is the appeal now?
Lordship, that I have to take in.
Then you go, you take your seat. No instruction. You people are not never prepared. Heard Mr. B.C. Das, Lanet Senior Counsel, appearing for the writ petitioner in WPC number 7216 of 2023. Also heard Mr. I.H. Saikia, Lanet Counsel, appearing for the respondent number. Acha. Also heard Mr. Ayub Saikel and counsel for the petitioner in WPC number 195 of 2023, Mr. S. Datta, and standing counsel, Revenue Department, Assam, as well as Mr. J.K. Goswami, learned additional senior government advocate, Assam, present on behalf of the official respondents. Both these writ petitions have been listed together on the basis of order dated 15/12/2023 passed by this court. So, the facts of the case involved in WPC number 7216 of 2023, comma, in a nutshell, comma, is to the effect that the writ petition that pursuant to the advertisement notice dated 3/9/2022 issued by the concerned authorities for filling up, inter alia for filling up the post of Gaon Pradhan in respect of charge number 33 of Bagbar, Moja in the district of Borpeta. The petitioner had submitted his candidature and eventually emerged as a successful candidate. However, the selection of the petitioner for appointment as Gaon Pradhan was called in question by the writ petitioner in WPC number 195 of 2023 by filing an appeal before the Lower Assam Divisional Commissioner under Rule 162 bracket C bracket close of the executive instructions framed under the Assam Land and Revenue Regulation 1886. Due to the aforesaid appeal and the pendency of several other writ proceedings instituted in the matter, the process of appointment of the petitioner as Gao Pradhan has been stalled. Mr. Das submits that at present, they even accept WPC number 195 of 2023 and the appeal referred by the petitioner in the said proceeding. There is no other pending proceeding coming in the way of appointment of the petitioner as Gao Pradhan. Full stop. Contending that there is no interim order coming in the way of issuance of the order of appointment, Mr. Das has paid for a positive direction from this court either to issue the order of appointment in favor of the petitioner or to dispose of the pending appeal expeditiously and in a time-bound manner. It appears that the issue involved in WPC number 195 of 2023 is pertaining to the prescribed age limit for appointment as Gam Pradhan introduced by Corriendum dated 27/10/2022, and therefore the same is not directly related with the question of legality and validity of the selection of the petitioner for appointment as Gao Pradhan. Full stop. Mr. Goswami, learned additional senior government advocate, Assam, submits that due to the abolition of the post of divisional commissioner, there has been some delay in disposal of these type of appeals. Full stop. However, according to Mr. Goswami, the principal secretary to the Department of Revenue
and Disaster
Management, Government of Assam, has now been entrusted with the jurisdiction to decide these appeals. And therefore, if a direction is issued by this court, the appeal pending with regard to the writ petitioner will be disposed of expeditiously. Mr. Saikia, learned counsel for the writ petitioner, in WPC number 195 of 2023 submits that until disposal of the appeal referred by his client, no order of appointment be issued in favor of the writ petitioner. Taking note of the submission of learned counsel for both the sides, and in view of the facts and circumstances of the case, writ petition being WPC number 7216 of 2023 is being disposed of with a direction upon the concerned authorities to consider the appeal filed by Hafizur Rahman,
being number RR 08/2023.
being numbered RR08/2023, and dispose of the same as expeditiously as possible, but not later than 45 days from the date of receipt of a certified copy of this order. Full stop. Depending on the outcome of the appeal, necessary steps for issuance of order of appointment in favor of the petitioner be taken without any further delay. Full stop. WPC number 195/2023 is segregated from this proceeding and listed separately for admission hearing in due course. This will be heard separately.
It is not there. Number 6 in 195 was it is not.
The petitioner is the respondent number 6
in 195.
Yes. Well, 195 is not a bar otherwise.
It is also made clear that pendency of WPC 195 of 2023 shall not be a bar for the authorities to take appropriate decision in the matter, in the light of the observations made here in above.
I think, Madam, I can submit.
Lord,
This case I was appointed as an amicus, my lord. Can this matter be taken up on 5th, my lord? I need some time to go through this voluminous file, my lord.
Yes.
5th of January, my lord.
All right. I had Mr. T. Chakraborty, our counsel for the writ petitioner, also had Mr. P. Chutia, learned Standing Council Education, Higher Education Department, Assam, as well as Mr. J.K. Goswami, learned Additional Senior Government Advocate, Assam, appearing for the official respondents. On the request of Mr. S. Chakraborty, learned amicus curiae, engaged in this case, this matter stands adjourned and be now listed again on 5/1/2024 for admission hearing as a fixed item.
My lord.
12 o'clock, there was a matter fixed. Yes. Yes, where is Mr. Nayak? All petitioners are working under the Directorate of Social Welfare Department.
My lord, all are not of directory in the district level, so the workshops, under department, only one department. Under the Social Welfare Department, Directorate of Social Welfare Department.
So in your synopsis, you have written they are all working under the Directorate of Social Welfare Department.
Yes, sir, yes.
Where is Mr. Nayak? All right, we'll dispose of this matter. Yes, what do you have to say? Why Social Welfare Department had sent the names of these people? They are employees, they are engaged under the Social Welfare
Yes,
Department.
Lordship. Yes, Lordship.
Yeah?
Yes.
Social Welfare Department was asked by the Finance Department to submit the list.
Yes, Lordship. That Lordship, on September 2005, Lordship, they submitted the government letter that it's so and so in regards to that the finance department is of the view that it is difficult to keep adding such personnel to the list. Many opportunity have already been given since 2019. That is the observation of the finance department, Lordship.
Where is the observation?
Lordship, paragraphs 3 of my affidavit, it is 106, page 106. Running page 106.
Yes.
Yeah.
Which paragraph?
Paragraphs 3, Lordship. The finance department is in of the view that it is difficult to keep the adding such personnel to the list. Many opportunity have given, already been given since 2019. The proposal is reclosed.
Where is the list in which the petitioner's names are there?
It was in Annexure 1, Lordship, 109, page 109.
This list contains the name of 48 employees.
Yes, Lordship.
And how many petitioners are here?
26.
13 million. 13.
So can you tell we'll confine the relief only to 13. We'll approach the court. Yes, heard Mr. C. Decker, learned counsel appearing for the writ petitioners. Also heard Mr. J.K. Goswami, learned additional senior government advocate, Assam. representing the,
It's
we'll confine it only to the 13 writ petitioners, that's all. Not the 48 as shown in the list.
Record or submission as it
Yes.
is there in the affidavit, Lordship.
Yes,
Otherwise, it appears, Lordship, his proposal was submitted with the sunset clause.
Hmm.
That is 16/9/2021. But some queries were made, Lordship, by the finance department and it was resubmitted.
When was the proposal submitted?
On July 7,
On July
7, 2021. And that was under consideration of finance department before the sunset clause, my lord. And they call for the list in prescribed form they have supplied. So matter is not a new one or not an addition.
All right, please. And the sunset clause came in when?
It was 16/9/2021.
This is Director of Social Welfare or Women and Child Development Department?
Yes, sir.
Huh?
Yes. I am appearing, Lordship.
No, who has sent this list? Director of Social Welfare or Women and Child
The
Development?
Director of Social has sent the list to Secretary,
Yes.
Social Welfare Department.
Yes.
And from Administrative Department, Social Welfare Department, they send the list to Finance Department.
Mr. Jacob Goswami,
Women and Child.
Government Advocate Assam, for appearing for respondent number. Respondent numbers 1, 2, and 4. Mr. P. Naik, Learned SC Finances, appeared for respond number 3. Full stop.
Three, Lordship.
From the case projected in the writ petition, it appears that the 13 petitioners were engaged as casual workers 26 to 40 years back. Out of the 13 writ petitioners, 11 of them are serving in grade 4, serving as grade 4 casual employees, whereas 2 are working in grade 3 casual employees post. Full stop. They are presently drawing the consolidated pay of rupees 9,000 per month. Consolidated wage of rupees 9,000 per month. Full stop. After the decision of the division bench of this court rendered in the case of State of Assam and others versus Sri Upen Das and others, third bracket, writ appeal number 45, public 2014. That is the affidavit of the finance department. Can you give me the page number?
Yes. Relying upon the paragraph 8.
No, but where is the affidavit first? Give me the page number of the
Yes,
affidavit.
118, Lordship.
Running page.
Second paragraph of first paragraph, Lordship, of 118, Lordship. That is relying.
Judgment, there is so and so Upen Das so and so wherein a direction was issued to pay minimum of the pay scale within quotes, minimum of the pay scale of rupees, within quotes, I have a minimum of pay scale. That is after the quote of rupees 15,900 with DA and medical allowance. The government of Assam through the finance department had issued notification dated 9/10/2017 instructing all administrative departments to forward the list of such casual employees within 31/10/2017. Is it correct? Huh?
31, 8,
30,
31.
Nine.
Yes.
Yeah, 10.
See, nobody knows anything, but the cases are happening. At this rate, we can only hear one case, or we can hear it after vacation.
No, my lord.
No,
Needs to be
but the facts are not known to anyone.
Lordship 3110 to. Page 117.
first 10.
Upon receipt of the proposals oblique list from the various department, the finance department had approved the case of 13,821 casual workers for payment of within course minimum pay scale, bracket, unquote, full stop. However, the case of the 13 petitioners could not be considered as allegedly there was delay in furnishing their names by the administrative department, which is the Department of Social Welfare, oblique, Child Welfare, is it?
Women and Child Development.
Women and Child Development Department. First up, the stand of the Finance Department is that by the time the requisite particulars of these candidates had reached the Finance Department, the within quotes, the sunset clause, unquote, had come into play, as a result of which no further list of casual employees would be processed by the Finance Department. Stop. Mr. Dekar, learned counsel for the petitioner, submits that the names of the petitioners in the list prepared by the Social Welfare Department, containing 48 names in total, was forwarded to the writ petitioner on 16/9/2021. That is before the sunset clause had come into, no, on 7/7/2021. That is before this sunset clause, within course, sunset clause had come into play with effect from 16/9/2021. Full stop. The Finance Department had called for certain clarifications from the Social Welfare Department with regard to the petitioners. But since there was undue delay in furnishing such clarifications, oblique informations, the cases of the writ petitioners were left out from from the benefit of the minimum scale, minimum of pay scale, which was extended to a large number of similarly situated casual employees, contending that it is a clear case of discrimination meted out to the petitioners for no fault of their own. Mr. Dekar submits that there was delay on the part of the departmental authorities to furnish the necessary information. pertaining to the petitioners, his clients cannot be held responsible for the same. Full stop. From the counter affidavit filed by the Finance Department, the stand of the departmental authorities is clear, which is available in paragraph 8 and is therefore being reproduced herein below for ready reference. Running page 118, double tick to double tick. Full stop. Mr. Nayak submits that the Finance Department has been receiving a large number of additional lists even after processing the final list prepared by the departments, and therefore it was not possible for the departmental authorities to continue to accept such additional lists. Full stop. The Learned Standing Council Finance has, however, submitted in his usual fairness that although the list containing the names of the writ petitioners were forwarded to the Finance Department before the sunset clause came into play, their names were left out only because the additional information sought for from the Department of Social Welfare was delayed by the authorities. Similar is the stand of Mr. J.K. Goswami, learned additional senior government advocate Assam, appearing for the state. After considering the pleadings of the parties and on going through the materials available on record, what transpires is that there is no dispute about the fact that the writ petitioners hearing are entitled were entitled to the benefit of minimum of pay scale within courts, minimum of pay scale, as per the direction passed by the division bench in the case of Upendas, Beckett Supra, and accordingly, their cases were duly processed by the departmental authorities. However, it appears that due to some communication gap and or delay in furnishing additional information to the department, the petitioners were deprived from the benefit of minimum of pay scale, which was extended to within course minimum of pay, which was extended to several other similarly situated casual employees. Having worked for more than 25 to 40 years as casual employees and being entitled to the benefit of minimum of pay scale as applicable under the judgment of the division bench rendered in the case of Upen Das Beckett Supra as implemented by the government of Assam, the writ petitioners cannot be deprived of the benefit of such pay scale merely because there was some delay on the part of the Department of Social Welfare in furnishing the additional information as sought for by the Finance Department. It is not the case of the department that the petitioners were not entitled to receive the benefit of minimum of pay scale.
Let the entitlement part be decided by the department, but delay in submission of documents not be a ground for non-consideration.
Full stop. Next para. Situated thus, this court is of the opinion that the petitioners cannot be deprived of the benefit of minimum of pay scale merely on the ground that there was delay in submission of in furnishing of additional information by the administrative department. Full stop. Whether the claim of the petitioners for receiving the benefit of such pay scale is valid or not is an entirely different matter, which will obviously be subject to scrutiny by the departmental authorities by applying the same standards as has been done in case of other similarly situated candidates. Full stop. In view of the reasons stated herein above, this writ petition succeeds and is hereby allowed. The respondents to consider the case of the 13 petitioners herein for granting the benefit of minimum of pay scale to them with effect from the date on which the other similarly situated
That is already there.
workers have been, casual workers have been given the benefit. The aforesaid exercise be carried out and conducted as expeditiously as possible, but not later than 90 days from the date of receipt of a certified copy of this order. It is made clear that this order will remain confined to only the 13 writ petitioners who are before this court. Writ petitioner stands disposed of.
For orders, item.
दिग्दार হৈছে নেকি বাৰু? দিগদাৰ হৈছে নেকি? ঠিক আছে।
May I please, Your Lordship? Lordship, I am appearing for PJ, Advocate PJ Fukon, for a respondent. And PJ Fukon is out of station, so another date maybe.
What am I supposed to do? What do you want me to do?
Another date maybe.
Another date. Oh.
Well, I am led by Senior Counsel Mr. K.N. Chaudhary, my lord. He will be out of station from 28th of January to 10th of February, my lord.
So you agree on a date? On the prayer of learned counsel appearing for both the sides who have expressed no, you write like this. A prayer for adjournment has been made in these cases on the ground that the learned standing counsel, PJ Fukon is appearing as standing counsel.
For Guwahati University.
Standing counsel for the Guwahati University, the PJ Fukon is not available due to personal reasons. And therefore, these matters be adjourned for 4 weeks. Full stop. Since the prayer is not opposed, same stands allowed. On the request of learned counsel for both the sides, let
8th of January, my lord.
Let these matters be listed again on 11th of January, 2024 as fixed items.
Right.
Yes.
My lord, I am appearing for respondent number 2. Lord, we have filed our affidavit, my lord.
You have filed?
Yes.
Is it on record? You have received?
Lordship, I have received, Lordship, but so far their affidavit is concerned, Lordship, order is not complied with, Lordship. Your Lordship may kindly come to the orders.
Yes. Where is the order?
Order is at page, Lordship, 8. 11 part, Lordship. First of all, Lordship, may kindly come to the point number 3. Paragraph number 3. Mr. So-and-so, Lanet CGC submits that he has received instructions to the effect that the petitioner's application for compassionate appointment would be considered by the departmental screening committee as and when they sit. Accordingly, the case was disposed of. Paragraph number 5, Lordship. In view of the above, this court is of the view that a time frame should be provided to the respondents to consider the petitioner's application. The departmental screening committee is thus directed to consider the petitioner's claim for compassionate appointment in its next sitting along with all other eligible candidates, which shall be done not later than 3 months from the date of receipt of a certificate copy of the order. This was the order. Now, Lordship, may.
My lord, may kindly peruse our affidavit, my lord.
Affidavit is not on record, is it?
Perhaps, Lordship, it is in the record.
Yes, it is on record.
My
Yes.
lord, may kindly come to page 19, my lord. By the communication dated 8/3/2018, all the recruitment process were kept on hold. Thereafter, my lord, the sitting of page number 21.
Yes.
All the next, page number 21, my lord. Sitting of for a compassionate appointment, the next meeting were not held thereafter. It was barred by this letter, page number 21, my lord.
No, but then there is a direction to hold it within 3 weeks.
Yes, my lord, but all the, my lord, may kindly come to the last page, my lord. Just.
Those communications.
My,
were
my
prior to
lord,
the-
my lord, may I just kindly peruse, page number 23, my lord, the last page. All the vacancies were abolished and by the Government of India, Ministry of Water Resources, page number 23, my lord.
Then you have to ask for a modification of that order.
My lord, it says by any means it cannot be fulfilled. This
Then
letter-
you ask for recalling the order of the court. You cannot just sit over the order.
My lord, that was duly communicated to the petitioner, my lord. By that, my lord, may- yes, my lord, may kindly, kindly say
Right,
that.
we'll direct personal appearance on the next date. In the meantime, if you want, you file applications for review of the order of the court.
My
You have to ask for recall of that order. You can't sit over an order. Heard Mr. H. Talukdar, counsel for the petitioner, on the request of Ms.
S. Kakoti, my lord.
S. Kakoti, and counsel appearing to the respondent number 2. This matter is directed to be listed again on 10th of January 2024 as a fixed item, so as to enable Ms. Kakoti to obtain updated instruction in the matter. If you don't file any review, then we'll implement the court order. You have to.
My lord.
You can't sit on an order of the courts. You have
My
to.
lord, I will.
Time to file my response to the affidavit filed by the,
How much time you want?
another week's time.
On the prayer of
Yeah,
Mr. R. Majumdar, learned counsel for the petitioner, 2 weeks further time is granted for filing rejoinder responding to the affidavit filed by the respondent number 2. Mr. K. Parasar, learned counsel has appeared for the respondent number 2.
Obliged.
Obliged. Yes. Yes, please.
Lordship will find the page 67 is the order which I am praying to review.
69, Lordship.
Just 69, 69.
Yes, 69. Yes.
Then Lordship may peruse the page number 63. It is an order dated 6/7/2023.
You are for the writ petitioners.
Yes, Lordship,
So why review petition?
because the certain issues were not placed properly before this court.
Lordship, it is a consent order, Lordship. They have agreed to the Lordship.
I try to satisfy the court, Lordship.
No, but you can't place new materials now. It's a
I am
consent
not-
order.
Yes.
I am not placing a new material, Lordship. I am relying on the prayer and pleading which are made in the writ petition. And this document, 6/7/2023, it is a part of the writ petition. And the public notice, it is later development, but the draft public notice was placed in the court as per the order. So Lordship, this order reflect that there was a excess acquisition of land beyond the DPR or notified area. And another issue is that as per the notification, 3 cutters of the land was acquired, but in actually 8 cutters of the land of the petitioner acquired. Then this order reflects that
Mr. You're Mr.
F.Z. Majumdar.
Yes, 3 minutes, then I'll pass the order. We can't entertain these things in a review
Yes,
petition.
my lord.
It's gone. It's a consent order. Your counsel has
Yes.
accepted it.
That is true, I am not disputing.
So then what
Lordship.
can be done now? This court,
But,
judicial
my-
proceedings must follow some discipline. The
Consent
same
order
court
that is-
cannot recall it and rehear the matter, passed in order. Heard Mr. So-and-so, learned counsel for the review petition also heard. Miss MD Bora Lanet.
Standing Council Transport.
Standing Council Transport Department license. Stop. Miss N Bora Lanet Council is applied for the respond numbers one. Standing Council NHA.
NHA.
One signature.
L Devi.
NHADC.
CGC for respond number one, NHS DC for respond numbers 2, 3, and 4.
4 I am appearing.
2 and 3, Miss MD Bora, Lanet, Standing Council Transport Department assigned for respond number 4.
2 and 3 I am agreeing.
2 and 3, yes, yes. This review petition is directed against the council order dated 4/10/2023, passed by this court in WPC number 5614/2023. The learned counsel for the review petitioner submits that certain facts could not be placed before the court on the previous occasion, as a result of which error apparent has crept into the order of the court. As such, the review petition be entertained and the read petition be reheard and disposed of on merit. Full stop. In order to bring home the above point, Mr. So-and-so has addressed elaborate arguments touching upon the merit of the case. However, as noted above, the order dated 4/10/2023 is a consent order which has been passed after taking note of facts placed before this court on instruction obtained as per the court's order. Full stop. Moreover, it is settled law that in the garb of a review petition, rehearing of the read petition would not be permissible. In view of the above, this court is of the opinion that there is no good ground to entertain the review petition. The same is according to law. You have to avail remedy in the higher forum. There is no other.
Lordship, one more observation may be given that
Review.
What observation?
that I may challenge the public notice by filing read petition.
Disposal of this review petition would, however, not come in the way of the read petitioners in availing appropriate legal remedies as may be permissible under the law, if so advised.
Deeply obliged, Your Worship.
33.
Yes, we wanted time in the morning.
Yes,
Why?
Your Lordship. Because, my lord, I have silenced this order, my lord, by a separate writ petition. WPC number, my lord,
When is the order?
7263.
Which order has not been complied with?
My lord,
Date of the order?
Order dated, my lord, order page, my lord, 12 of this contempt petition.
What is
Operating
the
parties.
date of the order? What is the date
Or
of the?
date of the order is, my lord, 29/4/2022. my lord.
Yes, what is the operative part?
Operative part page, my lord, 14, para 5, my lord.
So a recent order is to be passed.
My lord,
Where is has any order been passed?
here, my lord, the continuous length of service is to be taken into account, my lord. But they have not taken into account the total length of service. They have considered only, my lord.
But you have to
20.
challenge it.
Yes,
And
in-
I have silenced, my lord. And matter fixed on, my lord, 5 along with the contempt petition, my lord.
what survives in contempt petition?
Nothing survived, my lord. Nothing survived.
My lord, may be taken on, my lord, 5.
Heard Mr. M. Islam, learned counsel for the petitioner, also heard Mr. A. Bhattacharya, learned counsel appearing for the respondents who submitted that by speaking order dated 3/5/2023, passed by the Commissioner from a Panchayat and Rural Development Department. The claim of the petitioner has been addressed and therefore the order of this court has already been complied with. On perusal of the order dated 3/5/2023, I find that the submission of Mr. Bhattacharya is correct. At this stage, Mr. Islam submits that his client has assailed the order dated 3/5/2023 in WPC number
WPC number 7263 of 2023.
7263 of 2023, which is pending disposal before the court, and therefore the contempt case be kept pending. First up, the aforesaid prayer of the petitioner does not appear to be reasonable, and therefore cannot be accepted. If the petitioner has already filed a writ petition assailing the order dated 3/5/2023, the said petition will now be heard and decided on merit. Therefore, nothing survives in the contempt case as on date. Consequently, the contempt case stands closed. You already
Yeah.
filed a writ petition. You want a double barrel gun? Huh? Not possible.
Highly obliged, Your Lordship.
Miss, please, Your Lordship. Next week, we need 2 weeks time to, in this case, we need 2 weeks time, my lord. We have to take
For
instruction.
what?
We have to take instruction from the client, madam.
Your name, please?
V Baspo, Vinod Baspo.
Vinod?
Baspo, V Baspo.
Lordship, we have already filed the affidavit. Lordship, may kindly come to page number 29. There is a speaking order, Lordship.
Where is the order of the court? Which order has been violated?
Annex B, my lord. And the operative part is page number, my lord. 21, my lord.
Party part is page number 21.
Yes, madam. Page number 21, my lord.
Then where is the speaking order?
Speaking order is at page annexure 1 of page number, running page number 32 of our affidavit, Lordship. Page number 32.
So there is a speaking order
Lordship,
dated
there is a speaking order dated
25,
27th of May, no, June, sorry, Lordship, there is a speaking.
Your prayer has been rejected. Your
Lordship.
prayer has been rejected.
Yes, madam.
Challenge this order if you are aggrieved. That's all. Heard. Mr. V.
V Baspo, Vinod.
V for V.
V for Ben, my lord.
Vinod Bhaspur, learned counsel for the petitioner. Also heard Ms. M. Kotoki, learned counsel appearing for the respondent.
One and two, Lordship.
1 and 2, who submits that by the order dated 22/5/2023, a claim of the petitioner has been rejected for grounds stated therein. Full stop. Therefore, there is total compliance of the court's order. Full stop. Upon perusal of the order dated 23/5/2023, which is brought on record as a part of the affidavit filed on behalf of the respondent numbers 1 and 3, I am of the view that nothing survives for adjudication in this contempt case. The contempt case is accordingly closed. The petitioner would, however, be at liberty to assail the order dated 22/5/2023 in appropriate proceeding, if so advised.
Obliged, Lordship.
Respondent number 3.
Actually, you have for 1 and 2.
I for 1 and
Mr. Nath, then counsel for respondent number 3.
Comply.
Yes.
Specifically area monthly.
Order has been complied with.
No, my lord. It is partly complied. Area amount, that is provisional pension from my lord, March 22 to my lord, February 23 has been given. But monthly continuous provisional pension has not been, my lord, yet to be paid, my lord. And
today itself, Lordship, I have received the telephonic instruction, but even then, Lordship, that is the Lordship may fix it day after tomorrow. Let me get that instruction, as because I asked him.
All right, Mr. Siddharth, learned counsel has appeared for the petitioner on the request of Mr. H. Sharma, learned counsel representing the respondent.
1, 2, and 3.
1, 2, and 3. Let this matter be listed again day after tomorrow, that is give the date. First to enable it to obtain complete instruction. Mr. A. Hassan, learned counsel is present for the respondent number?
4.
4. Order complied with?
Yes.
Mr. A. Rashid, learned counsel is present for the petitioner. Mr. D. Nath, learned counsel appearing for the respondent numbers?
1 and 2, both.
1 and 2 has produced a copy of the order dated 9/11/2023, passed by the commandant, 7th A full stop P full stop battalion BN, Sarai Khola, Kokrajhar, to submit that order of this court has been complied with.
The 5th line from the bottom of the first paragraph. The removal from service is hereby changed to compulsory retirement. As observed by the
And the
Honorable
penalty of removal from service of the petitioner has been,
husband of the petitioner.
husband of the petitioner has been converted into one of
Compulsory
compulsory retirement. First up, Mr. Rashid has not disputed his said position. As such, by retaining a copy of the order dated 9/11/2023 on the record, this contempt case stands closed.
I may file fresh case if
That is always there. You don't need.
I need a copy of the order.
Yes, yes, I'll provide that. Malad, the, as, the next line to that, Malad, as observed by the Honorable Court, order will be will have prospective effect. It was given in that order only that they have written.
That whatever
Lodge.
is happening.
Lodge. So I'll give you order.
Give a copy, otherwise you will take it from her.
I'll give you. I'll give you.
Yes.
Pursuant to the earlier order, Lordship, we have taken steps, Lordship. We have taken steps pursuant to the earlier order, but as per office noted 1512, Lordship, service upon respondent number 2 and 3 is yet to be completed, Lord.
Mr.
J.M. Gogoi, Lord.
J.M. Gogoi, learned counsel is present for the petitioner. As per office note dated 15/12/2023, service report on respondent numbers 2 and 3 are still awaited. In view of the above, let this matter be listed again in the second week of January 2024 with appropriate office note.
Make legal, Lordship.
My lord, your lordship kindly see the order passed by your lordships on 11/10/2023. Now, this person, my lord, she was appointed in the post of Khalasi in the office of Executive Engineer, Water Resource Management. Now, she had worked there for 4 or 5 days. Then the head clerk came and said, give your appointment letter for some correction. Then next day she asked for this appointment letter. He said that you need not come from so and so after 2 or 3 days. Now, this is the state of affairs which is going on. I don't know. And even, my lord, if the order was passed by your lordship on 11/10, my lord, the government has failed to file any sort of affidavit. Why they have done all this?
Lordship may grant us some time after a vacation, the matter may be fixed. In the meantime, we will file our affidavit, Lordship.
Why it has happened? The appointment order was given, then it was taken back.
Yes, Lordship.
Why?
Lordship, no instruction till now, Lordship. Some time may be granted, Lordship.
So we'll give him one chance. After that, hammers will fall.
My lord, till such time, my
What
lord,
can be
if
done?
they don't occupy, my lord, they might do all these things. Then on compassionate appointment, they fill up that post.
The post of, the grade 4 post of Khalasi
Khalasi.
claimed by the petitioner shall not be filled up.
Right.
Mr. S. Dattal and a senior counsel assisted by Mr. S. Dattal and a counsel for the writ petitioner. Also had Mr. C. Sharma, learned counsel representing the respondent numbers 2 to 4. Yes, A. Talukdar, learned counsel has appeared for respondent numbers 6 and 8. None has appeared. Mr. P. Nayak, learned SC Finance is present on behalf of respondent number 1.
Lordship,
By
I am for 4 and 5 only.
Mr. 4 and 5. It has been wrongly reflected in the previous order then. 4 and 5. So, Mr. Nayak for 1, who is for 2? 2 is not there. 3 is,
Two is there.
who is 2?
Lordship, I am for 2.
Mr. C. Sharma for 2, 3?
No.
Achha, 2, 4 and 5.
2 and 4, Lordship. 2 and 4.
2 and 4.
And for 3, Lordship.
Ms. A. Talukdar for respondent number 3. 3 and?
Only 3, Lordship.
Only 3. None has appeared for the remaining respondents. By inviting the attention of this court to the order dated 11/10/2023 passed in this proceeding, Mr. Datta submits that the respondents are yet to file affidavit. Full stop. Contending that delay in the matter is causing serious prejudice to the interest of his client. Mr. Datta has prayed for an interim order protecting the interest of his client. Mr. Sharma, learned counsel, has however prayed for 3 weeks further time to file affidavit. Anybody else is filing affidavit? In view of the above, and on the request of learned counsel for the respondents, this matter is directed to be listed again on 24th of January 2024 as a fixed item. Counter affidavit on behalf of the respondents be positively filed on or before 22nd of January 2024. As an interim measure, it is hereby provided that the post of grade 4 bracket Khalasi as claimed by the petitioner shall not be filled up in any manner till the next date.
Much obliged. My lord, I have one short prayer. My lord, in regard to item 22, your lordship has disposed of the matter, that's okay, my lord. My learned friend could not point out to your lordships that the petitioner is retiring on 24th July. So the disposal may be, my lord, within 45 days.
We'll make it 3 months.
Oh, my lord, yes. Much obliged.
Matter of termination of service, my lord, after disciplinary proceeding.
Hmm.
My grounds of challenge are mainly that it is not a misconduct under the rules, whatever I had been charged with. And my lord, there are also procedural lapses in the inquiry proceedings.
You have the records.
Yes, madam, I have submitted before court number 13 years. That may be with Aseniki record too. Yes, my lord, these are the record official. record.
This matter was heard by that court.
Yes, court number 13. Hindi selected. Yes,
On an
ma'am.
earlier occasion, lordship had taken it up, then it had come up before court number
Court
13 and now again it is before lordship. my lord. There was no part heard or any last occasion only.
So what is to be done today?
My lord, otherwise it is ready for hearing. I would be
Yes, ma'am.
more comfortable my lord, if it is taken up immediately after the vacation.
Yes, my lord.
Today,
Don't have objection.
a week's more would not come, my lord.
Immediately after the vacation. Which date? Give me a date.
My lord.
Fourth.
23 or
Me লগত মিলোৱা
No, it was.
24 আহিছে
4th is Thursday, my lord, 4th.
Mr. R. Majumdar, Learned Counsel for the petitioner is present. Sri Gayan Learned CGC submits that the records have been received and the matter can be heard finally. In view of the above and on the request of Mr. Majumdar, this petition is directed to be listed for final hearing again on 4th of January 2024 as a fixed item.
My lord,
Yes, most obliged.
I'm obliged.